speaking of questions, I'm going to, if you're okay with it, I'm going to ignore the people in the waiting room and rely on someone else to let them in to keep me from getting distracted. Is that okay? Okay, super. All right. As far as questions, if you have a question at any point, you find some way to get my attention by like waving, I'll do my best to pay attention to that. But if you put something in the chat that you have a question, I'll pop over and try to answer it at that point, or you can save your questions for the end. I really don't love to get them typed out in the chat because number one, I can't focus enough to avoid reading them while I'm speaking. So then everyone else is going to have to deal with me reading it. And a lot of times there's context needed for questions. So I'll have a couple of follow-up questions. And so tell me you have a question in the chat and then let's ask and answer it live. All right, so first starting out with a seminar like this, especially regarding a topic like LGBTQ, the question is, what is the angle of the seminar? And so here I am an employment lawyer. I generally do defense of claims or counseling for employers. So the idea here is advice to employers, how to handle the issues that do come up with respect to having members of the LGBTQ community as employees, and these issues are evolving as the law evolves. I'm going to talk about the current state of the law, and as a disclaimer, it's hard to avoid a seminar like this feeling political to people who have big opinions, and I will not talk about politics at all, but it's going to be fairly obvious throughout that I am an ally to the LGBTQ community. And so it's not a subject that is political in terms of employment law. To set those thoughts that you might have aside for the purposes of this, we're going to talk about your obligations as employers. We're going to talk about the rights of the employees as well as the rights of the employers. So just to set that out there in the beginning so no one has any apprehension of what to expect. Oh, goodness, perfect timing that one of my dogs is upset with the other dog, so forgive me. Alrighty, so let me see. I'm working two screens right now. I'm trying to ignore the dogs. Current state of the law. So a lot of hype was surrounding, that's why I use a little breaking news screen here. A lot of hype was surrounding the June 15th, 2020 decision by the United States Supreme Court. And from an employment law perspective, this deserved hype. From a New Jersey law perspective, it really didn't. And I'll explain that. So Justice Gorsuch is a new United States Supreme Court justice, and we really weren't sure globally or nationally as attorneys what to expect from him. Obviously, he was appointed by the current presidential administration and thought to be a very conservative-minded justice. And at the same time, we had some very important LGBTQ cases, as well as many other important cases before the Supreme Court in this past year. So prior to June 15th, 2020, there was no federal protection for sexual orientation in the workplace. Many states had protection, many cities, many counties. However, federally, they hadn't addressed the question. And so the idea is, do you create new legislation or do you try to sneak extra protections into current existing law? And Justice Gorsuch, which surprised me and probably surprised a lot of people, was the authoring justice on the opinion, which included protecting discrimination or protecting individuals who are homosexual or transgender under the word sex within the statute. One flaw that I have is that I really find the law interesting, and sometimes I forget how boring it can be to other people. So if I feel jazzed about laws and employment laws and definitions, that's just because I'm a nerd, and so we have to own who we are. And so squeezing in all of that protection under the word sex is not a new thing, but it's pretty exciting that the United States Supreme Court has decided to at least extend the protections to this population. This law was, it's the Civil Rights Act of 1964, which you really don't need to know about. Tell you anyway. New Jersey law against discrimination. So this is why when I said it was exciting from a national standpoint, but not so exciting, the June 15th, 2020 decision from a New Jersey standpoint, That's because we already have such a all-encompassing law against discrimination in New Jersey. We are one of the forefronts of protection statutes and protection states, which is super. We deserve definitely an A+ for, or at least an A, for our protection efforts in the state of New Jersey. So it is New Jersey Law Against Discrimination. We, in the lawyer world, we call it the NJLAD or the LAD. And first enacted in 1945, this was actually the first anti-discrimination statute in the country. So whenever you see one of those things on Facebook that's like hating on New Jersey, and you can say, we had the first anti-discrimination statute. So like, look how awesome we are. And we also have really great pizza. So 2 for 2. And over the years, it's been amended a number of times to add more groups of people for protection. And I'm not going to go over each of them because I think it would be really actually hard to recreate each step. And I'll tell you where we are now. So this is the current New Jersey Law Against Discrimination protected classes list. And I've italicized and underlined the ones that the federal court has all stuck under the word sex. And yet we've broken them down in the state of New Jersey, our legislature, to include sex, sexual orientation, gender identity or expression, relationship status, including marital, domestic partnership, or civil union status. And I thought about highlighting and or italicizing and underlining familial status too, but that is a slightly separate subject. So this is extremely protective, and I think that deserves a lot of attention for New Jersey employers, because you have to understand each of these separate sections to understand what you're responsible for protecting under the statute, but really it's an anti-discrimination statute. So instead of thinking that you're required to protect, I know a lot of employers think, all right, what am I not allowed to do? Well, you're not allowed to discriminate on these bases. Okay, comparison. I really kind of jumped ahead and covered this already. So we have everything that we're protecting in the federal laws under the word sex, and then in New Jersey law, we have lots of different words that we're using to protect the community. Important definitions. So I struggled a little bit with exactly which words to define, because I have to handicap it a little bit to the audience that I'm expecting. I figured I would get employers who are concerned about protecting LGBTQ employees, employers who are concerned that they might get sued by LGBTQ employees, as well as members of the community themselves. So some of these definitions, many of you won't need at all. Some of these definitions you might be hearing for the first time. So cisgender is a person whose sense of personal identity and gender corresponds with their birth sex. So if you were born female and you believe yourself to be female, you identify as female, and you are comfortable with that, then that is the definition for you. Transgender, which I think everyone probably understands at this point, even those who've kind of buried their heads in the sand a little bit, understand that it's a person whose sense of personal identity and gender does not correspond with their birth sex. We'll talk a little bit more in depth about that and how it impacts the workplace a little bit later, but for now I wanted to step forth the definitions. And then definitions continued. I have a lot of different kinds of clients, and they really do run the gamut of inclusive and diverse employers, as well as employers who've traditionally had 2 or 3 employees. They might be family members, they might be neighbors, and they don't know what the heck I'm talking about here. And I know a lot of them are thinking, oh gosh, Shane, just hold my hand and tell me what I have to do. So that's kind of the help. Where do I begin? Definitions continued rather than setting them all out. Gender neutral, non-binary, I think there's probably some thoughts on whether they should be lumped together. I lump them together just for ease, because I know I could probably talk an hour about trying to make sure I fully explain each of the definitions in a way that's comfortable to everyone. Generally, it encompasses individuals who do not believe themselves or do not identify with either gender. And then we have gender fluid, which is someone who believes that at any given time, gender is more of a fluid subject. And so you it's not a fixed constant on the scale, and as well as transgender, which is kind of more encompassing, that you are a little bit of all genders. And I think that and gender fluid maybe need to be next to each other. But as a lawyer, I can really delve into some definitions, and I don't want you to get lost there in the weeds. What I want you to understand the definitions so that if I mention a phrase, you know what I'm talking about. So queer, with the LGBTQ in the seminar, even I, who consider myself to be an ally, I have some actual real life friends who've tuned in today who I think would probably agree with me. I hope they would agree with me. And even I was like, wait a minute, what is the Q? What does the Q even mean? So I Googled it for the purposes of including the Google in my presentation. But I thought, rather than me stumbling through definitions that might not come completely naturally to me in a recorded Zoom, I would Google it, let you read the definition, and that way I'm not responsible for the accuracy of my definition of the word queer. It really seems to be, I hate to use the word catch-all, but it seems to be a little bit of a catch-all. It's interesting then from a legislation standpoint or from a use of an acronym standpoint that it got its own letter, but that could be a subject of another seminar for another day, of the significance of the letter Q. So how does all of this impact the workplace? At this point, you might be thinking, oh my God, she's going to ramble about all these different groups for this entire hour. And so no, that's not going to happen. I'm going to bring it back to how does this impact the workplace? I am an employment lawyer after all. And so I'll talk through each of these most important steps or most important aspects of the workplace. So we have addressing the employee applicant, hiring decisions, discipline decisions, and then treatment at work, policies and harassment. There's probably more, but with an hour of time and a topic that I could talk for hours and hours about, I think that's all we could cover. So what are your pronouns? Just when you thought I was going to give up on the definitions, I'm going to hit you with a couple more. So you don't need to memorize these right now, and I am not asking you to. And in fact, there are actually more pronouns than this, but I didn't want to make every employer panic about some of the more uncommon pronouns. So this is just straight out of little kids' school learning. What are the pronouns? Subject, object, possessive, and then the other possessive. And so what am I talking about here? Some employees are going to make this really easy for you. And so if you have an applicant who puts pronouns on their resume or their email signature or their other official document, use them. And I'll give you an example here. I deal with a lot of clients who I know well. I deal with a lot of clients who I've never met. And sometimes they're insurance companies who I've certainly never met, the new adjuster that I'm dealing with. Sometimes they have like the most plain Jane American name. I know exactly which gender they are by virtue of their name. John Doe here. We can all make the assumption based on all the information that we've learned of our time in the world that John Doe here is going to be a Mr. when I write Dear Mr. Doe in my email. But that no longer may be accurate. I can't make these assumptions just based on John Doe's name, as well as a lot of times individuals, and we'll talk about this a little bit, who are non-binary or who gender neutral or who have transitioned, maybe are using a different pronoun. And so I'm not asking you to guess. I know you don't have a crystal ball, and I'm not asking you to delete all of your Mr. and Mrs. or Ms. or whatever it is that you use. But I am saying if somebody bothers to put it on their application or bothers to put that on their resume, absolutely respect what they've put. So if John Doe says that her pronouns are feminine pronouns, use them. Even if I can see, I have an assistant and she's super, she's been with me for 11 years, but I can definitely see her correcting me, knowing you got this wrong. You said Ms. John Doe. And so pay very close attention to that, especially when you have someone correcting your work like I do. But if you see any typos in this presentation, for the protection of my assistant, I typed this all by myself. She never saw it. So any mistake is mine and mine alone. All right, so here's a little bit of an example. I started my own resume just for the purpose of this and put underneath pronouns, she, her, hers. And admittedly, in my real resume, not that I've been with Cooper Levenson for 2005, so not that I have much use for my real resume. At the same time, on my real resume, they're not there. At some point, will I add them? Probably. I think that we're trending in that direction, but that's a decision you have to make for yourself. I'm talking about from an employer perspective. When you receive an application or a resume, keep that in mind and pay attention to that. The first way you can commit discrimination against someone who is in the LGBTQ community is by ignoring their pronouns when they very clearly set them out. So right now, I've probably got a few people back on their heels, and so I want to make sure that I'm clear. Your opinion, your employees' opinions do not matter when it comes to anti-discrimination. So if I started to ruffle your feathers a little bit by talking about definitions that that don't come naturally to you, or that you're not entirely comfortable with, or that this is a new subject for you and you think, holy moly, what are they talking about? This is all new. Our opinions, my opinion, no matter what it is, it doesn't matter. These are the anti-discrimination statutes that we have. We're operating pursuant to the laws of the state of New Jersey and the United States. And so set opinions by the wayside right now. We're talking about anti-discrimination statutes and protections. Just making my point even further. Sometimes I get carried away. Discrimination, even inadvertent discrimination, is harsh too. Just as harsh as being told that I'm minimizing your opinion for the purposes of today. So ways not to discriminate. How can we avoid discrimination? I just told you that even inadvertent discrimination is against the law. And that is what I am seeing most often with LGBTQ discrimination. Admittedly, I haven't seen a ton of litigation, and I'll save you my analysis of why that is, but I think a little bit of failure to report and an avoidance of the drama that comes with bringing litigation. I don't think it's because of a lack of discriminatory action. I think it's decisions by the victims not to come forward. And so we want to avoid the attrition that comes with discrimination. We lose good employees. We want to avoid the office morale and upset that comes from discrimination, inadvertent or otherwise. And obviously, we want to avoid discrimination just generally. So ways not to discriminate, we'll go through them. Hiring decisions. Obviously, I think everybody knows at this point, if I put it in the list of things that are protected under the New Jersey law against discrimination, you're not allowed to discriminate against someone for their inclusion in that protected group in your hiring decisions. So let's say you have a 10-person office, you kind of think of yourselves as a family. That's often something that I hear from clients, where we're a group, the guys go out to lunch together, the girls go out to lunch together. We don't know where someone who doesn't fit within our definitions would go to lunch, and that would make everybody uncomfortable. Or some other rationale as to why a decision is being made against hiring a member of any protected group, including members of the LGBTQ community. You can't discriminate on the basis of any inclusion of those protected classes. Discipline decisions. So this one gets a little bit more nuanced, and this is one where I think we see some more of the accidental or inadvertent discrimination. Sometimes we see that across the board with race as well, and age even, gender. So this isn't something that's exclusive to this group. When you're making employment decisions, you can't discipline more harshly or discipline less harshly someone for their inclusion in a protected group. And then I'm going to break these down a little bit more. Treatment at work, policies, and harassment. So, all right, I've hardly mentioned the LGB and Q parts of LGBTQ because that part should already be easy. Let's not discriminate, let's not tolerate discrimination, and don't issue discipline or praise inconsistently. All right, how might you be discriminating? So I'm talking right now about policy. Here's an example of how you could unintentionally discriminate and actually still feel like you're following the law. And I see my great idea of squeezing this all on one slide backfired because it's hanging over the bottom a little bit, but I'll go through it anyway. So I had to put on my creative thinking cap of ways that policy or law could still discriminate because no one ever asks me these questions in my practice. Friends sometimes ask me, but no, this has not been a subject that's come up with my clients. Do you have an employee who, and admittedly, by 2020, this problem should start to resolve itself, but maybe someone was in the civil union or domestic partnership who moved to New Jersey from a state where previously same-sex marriage was not permitted until 2015. They moved here, they planned their big wedding for 2020, and then 2020 took its terrible toll on everyone, and now they are not spouses under the definition that you might want to utilize for spouse, that the FMLA utilizes for spouse, and they want to take some time under the FMLA to care for their ill domestic partner or that partner's child. And so this gets us to the question of, what do my clients ask when they call me? And they ask the question one of two ways, and I've gotten really good at listening to how they phrase their question, because as much as I want to give them the accurate answer, I also don't want to tick them off every time I answer their question and tell them what they don't want to hear. So I massage the answer so that it's more palatable, whether it's what they want to hear or they don't want to hear. And so sometimes they call and ask me, Amy, do we have to let this person take leave? So what they are looking for me is from some reason under the law to avoid allowing somebody to take leave. And that could be for a good reason or bad reason. It could be that they're short-staffed and that they can't afford to have somebody take the leave, or it could be that they act like that every time somebody asks for the leave. They might ask me the opposite way. And it might be, Amy, are we allowed to let this person take the leave? And then I know they want to, but they're worried that they're going to get themselves in hot water for being too permissive or giving too much leeway under the law. You might be thinking, that can't be possible. You can give all the leeway you want. Sometimes it does land employers in sticky situations where they bend the law for some and don't bend the law for others. And so I do understand why they ask it that way, and I understand why the other employers ask it the other way. This one is one where an employer, this example is one where an employer might have asked me, Amy, do we have to let them? And some well-intended attorney might say, no, you don't. You don't meet the definition. You don't have to let them. And so that is, I would say, bad advice, because you might not be violating this particular statute. You're not denying them a right that they're allowed, but you are potentially at least engaging in an act that would be evidence of discrimination. All by itself, would it be discrimination enough to stand a suit? Maybe not, but would it be added to the pile of other inadvertent things you've done and be evidence of discriminatory decision-making at your workplace? Possibly. So it's time to really open your eyes to the decision-making that you're making and why. And, you know, why are you hesitant to allow this person to leave where you wouldn't have hesitated for a second if they were just married in the state of New Jersey? So I crowdsourced yesterday among my actual friends, and I wanted examples of policies that appear to be neutral on their face that disproportionately impacted my friends who are members of the LGBTQ community. And I was clear, I don't want a bunch of anecdotal stories. I know that from just chatting that my friends who are members of that community have experienced discrimination. I wanted to know neutral policies that have resulted in disproportionately discriminatory decisions. And I did hear from one, and I had a vague recollection of when it occurred, and so it wasn't a surprise to hear it. But I'll set out the facts. Obviously, I'm not going to tell you anything about the people, but this is a lesbian couple, and quite a few years ago, maybe now we're about 10 years ago, they lived in the state of New Jersey. One of them worked in the state of Pennsylvania. Her office, which was a law firm, which I think is an interesting note, offered fertility treatments to married couples. At the time, Pennsylvania did not have same-sex marriage, and my timing might be off, and I didn't check which year that was permitted. Our kids are about the same age, so I'm going to say it's about 10, maybe 13 years ago. In New Jersey, we did have same-sex marriage. They were married in the state of New Jersey at the time of this situation. They were denied the use of the fertility benefit at this Pennsylvania law firm because it was a Pennsylvania law firm, and in the state of Pennsylvania, they did not recognize same-sex marriage at that time. So this New Jersey married couple was not able to obtain the benefits under the law. I think that would have been a case that I, at the very least, would have wanted to see as a test case. How maybe it was too early for the federal government to be testing at that point, but that's one time where I'm sure that law firm thought that they weren't doing anything discriminatory, but it feels a bit discriminatory, and so it certainly had an inadvertent impact on that individual. So how can we avoid harassment? Forgive me, I need to take a sip. So jokes and comments, drawings, photographs, sudden invitations to drag shows. This is the way that we're seeing harassment. And I have to admit, I think the media, they get blamed for a lot. I think TV shows, movies have a lot to do with the reason people are so quick to harass members of the LGBTQ community in their attempt at giving my philosophy on what I think the Hollywood is doing, is trying to make it so that it's more inclusive, everybody's more comfortable with individuals. But what they're doing is they're almost always the funny one in the TV shows. It's almost always a token character who's hilarious or who's exaggerated. And among individuals, if you think of friends or family members that you have that are lesbian, that are gay, that are trans, they might themselves be exaggerated in the way that they demonstrate their inclusion in this community. And maybe that's personality, maybe it's a defense mechanism, but combined, this creates a situation where I think members who are not members of the community and police who are not members think it's cool then that you can joke. It's fair game because it's hilarious on TV, and it's almost like if you own it, then maybe everybody, it's hard to pick common characters that everybody knows, because now with the world of Netflix, we get to pick what we say, so we don't all know the same people. But if you recall the character Fat Amy, well, she owns it. And my name's Amy, so obviously I think about her. She said Fat Amy first, and then that way it's cool to joke about, like, oh, Fat Amy, that's okay. So don't fall into that trap. Just because an employee that you have is a very openly vocal advocate of gay, of lesbian, of the entire community, does not mean it's okay to start joking about it. It does not mean it's cool to print out a picture of a drag queen and stick it on their computer. That it's not funny. And so you might be thinking, no, Amy, you're such a killjoy. And I hear that all the time. People do groan when I show up at the offices, not my own, well, sometimes my own office, but not my own office, but at a client's office. When I walk in, they're like, oh, crud, why is she here? What did we do? And that is, it's time to get serious. And my question would be, okay, so you guys got your hands on a picture of this male employee in a jacuzzi full of bubbles, and you hung it up all over the office, and he happens to be a gay man. Tell me why that was funny. And I don't mean it mean, I'm not picking on them. I'm, usually in that situation, I'm either investigating or I'm their defense attorney. I want you to tell me why it was funny, because you're gonna have to tell a jury why it was funny. So break it down. Pretend I'm in 3rd grade. Tell me what was funny about it. And so think of, a joke that you've made, maybe that you regret, and try to imagine right now telling me why it was funny. If it's uncomfortable to explain it, or if you're going to have to explain like nuances of discrimination and rationalize away from it, don't say it, don't do it. And as employers, you might be the only supervisory staff that you have, or you might have individuals who you've authorized as supervisors, managers who work for you. And so this is really important to communicate to them as well. this is a situation where you buy their conduct when it comes to discrimination. So you make sure that they understand that it's not funny. I'm going to loop back into many employers, especially I know in Cape County, are small employers. You have a lot of big employers too, but you have a lot of small employers, and a lot of your workplaces are very family-like amongst everyone, which blurs the lines in a good way and in a bad way. So in a good way, somebody's car breaks down and absolutely everybody jumps up to drive them home, now with masks on and in the middle of a pandemic. But it also blurs the lines in that we get more and more comfortable making jokes about things, that we get more and more comfortable asking a lot of questions or being inappropriate in the workplace. And that transcends not just when we're talking about LGBTQ, but also when we're talking about any discrimination. So remember that no matter how much of a family your workplace feels like, on the day that you're sitting at the defense table and that family member of yours, in quotes, is sitting at the plaintiff's table in a lawsuit, they don't feel much like family anymore. So tell me why that was funny. And if it's uncomfortable to say, don't say it. Can't we joke anymore? And so this is where I try to explain that I'm not a killjoy, I swear. We can't joke when someone's protected class is the punchline. So yeah, absolutely we can joke. And we can joke about all sorts of things, but we can't joke about the protected classes of our employees. All right, this is the final issue I'm going to tackle. This is one that is becoming more frequent. This is a little bit of foreshadowing of what I think we see in employers coming down the line. It's not something that's been at the forefront of my practice, certainly. We have employees in transition. So when we were talking before about all the different definitions, we didn't talk about individuals who are transitioning from male to female, female to male. And that might be medical, it might not be medical, but it is, if you Google employment training videos, which I Google that a lot just to keep myself abreast of things, then you'll see that's one of the new ones that they're making all those little mock-up videos. There's one that I really think is helpful. If I were technically advanced enough to figure out how to work 2 laptops and incorporate a video, I would have played it for you today. But instead, I will bore you with telling you what the video showed, which is an individual who clearly recently transitioned from male to female, who worked at an office for a really long time. So I'll use myself as an example because I'm always the easiest one to pick on. I've been at Cooper Levenson for a little bit over 15 years. So let's say that today I announced to everyone that I am going to transition and that I'm now going to utilize male pronouns, and I'm also going to utilize a different name. And so instead of Amy, pick a male gendered name, and that's going to be my new name. I've realized that would be extremely difficult for everyone that I work with to make that transition. Now, admittedly, it would also be out of left field because I've never given any clues, and so this is a example that's lacking in a lot of ways, but it's easiest to pick on myself. So would some people think it's so out of left field that it's fair game for joking about? And I'm pretty good humored usually, and so everyone might think, okay, Joe. And sometimes when things are uncomfortable, our defense mechanism generally is humor. So whether you're the inadvertent discriminator or where you're the victim, humor is how we avoid dealing with the seriousness of issues. So that's one issue that I predict is going to be a problem with employees in transition, as well as in a video that I'm not showing you, the one male employee keeps referring to the old name, the previous name of the employee, and he gets confronted on it. He's getting in trouble at work. And it's like, look, you're the only one. It's been months. You're the only one who can't seem to get it that they are utilizing a different name now. And he said something like, God, they worked here for 15 years. Give me some time. I'm doing the best that I can. And in this video, this guy who's the bad guy in the video believes himself to be a victim. Now he's trying. he keeps making a mistake because he has worked with this individual for so long. And so you might feel a little bit bad for him. And the point of the video is, no, that person is not the victim in this video. The individual who's made the extremely difficult decision to transition and to advise everyone at work about this, change their name, change pretty much everything about the external portrayal of themselves to the world, they are the ones who are the victim in this story. And so I know this is a lot to grasp. A lot of employers are going to be like, oh my gosh, Aim, this is just too much for us to absorb all in one 45-minute presentation. But what can we do? What's the takeaway? Be supportive if this is an issue that comes before you as an employer. And what I mean by that is maybe you don't know how to be supportive. So ask how they'd like to be supported by the company. If someone were to come to you and say, hey, I know I've worked with you for 15 years. I am going to transition now from female to male or from male to female. And I just wanted to let HR know, or whichever person we utilize for HR in the company. The easiest and least risky, least discriminatory, and honestly, I think the most compassionate thing to do is to say, okay, how would you like us to support you? How would you like to be supported by the company? And if you're doing things for the right reason, then the right reason meaning in accordance with the law and trying to be a good person, then you're going to be safe from the sword of the employment laws. Some people look at them like a sword, some people look at them like a shield. It doesn't matter which way you think of them, but think of them. And so one thing I didn't touch on, I know I said final issue, but one thing I didn't touch on was the use of the pronoun they. I saved it for the end because I didn't want to run out of time. And so when you have an individual who puts on their application or puts on their resume or advises you that they utilize the pronouns they, this is sometimes a difficult thing for people to grasp. And it's a little bit awkward in usage. And it's extremely important. And so I wanted to give you a couple examples of how to make it less awkward and how to train your employees. And right on time, my next door neighbor is getting their lawn treated. So if you hear the beep, 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 that is me, not someone who's unmuted, backing a vehicle into the neighboring yard. So as far as an individual who uses the pronouns they, if you've never heard that before, you might be saying, wait a minute, they is a plural and we're talking about an individual. Amy, you're just killing me today. Well, okay, we have to get past that. Sometimes they is a singular pronoun. And in what circumstances should you be using they? Let's say you have an applicant who doesn't put any pronouns at all on there and you're not sure. Are they male or female? And it's almost like I set this up. Now, do you hear the fire alarm? We have a fire whistle in my town. So it's like I've tried to do every single thing to interrupt today just for your enjoyment. So you're welcome. So you might be thinking that they is a plural and it can't be singular. It can be singular. So an example, if you have someone who applies and they come in for their interview, they have kind of a non-gendered name, so you're not sure, oh my gosh, is this person male? Is this person female? I'm not sure what to say. Sam, their name is Sam. It could go either way. I don't know. If you don't feel comfortable asking, I think you can get away with using they and no one would even ever notice. And you might think that people will notice, but I assure you they won't. So I'll give you an example. And I took this example from a seminar that I attended and I thought it was the best one I've heard, which is, let's pretend the person's not there and you're describing them. So really, if you're one-on-one with someone, you don't usually use their pronouns anyway. So this is when you're introducing them to somebody else. And so let's say we have Sam, the applicant. I've decided I want to hire Sam. I'm going to introduce them around the office and I'm going to show them their potential office. And so lo and behold, we run into somebody else in the office. And so I say, hey, Sue, meet Sam. They are interested in working here. They might start on February 1st. And so that I talked about somebody else's example. That wasn't their example. Their example was, let's pretend they're not here at all. and the person left their umbrella in the conference room. And so they're not there. We don't know whose umbrella this was, so we don't know the gender of the individual who left the umbrella. And if you start thinking about it, we are very tied to gender when we're describing people, when we're using pronouns. So now we're not tied to gender anymore because we don't know the gender. Somebody left their umbrella in the conference room. I hope they come back for it. Now, I don't want to make it seem like I'm the white knight of LGBTQ inclusiveness. I screw this up too. And I'll give you an example. I have a family member who lives with other individuals who are not directly my family members. They have a child who's non-binary. Before this child decided that they would identify as non-binary, and decided is a tricky word. I'm going to ask you to forgive me for right there, but I also have a daughter. So these three are the same age. I almost said these three girls because that's how I was referred to them before. You know, hey girls, slow down. Hey girls, come on. I still mess up sometimes, and it's been about a year. It's usually in a situation where the three of them are about to run into a street. That's how I'm getting rationalized. It's usually in a panic situation. I'm doing my very best, but I do still make a mistake. And then I have to grapple with, is it worse if I address it every time? Oh my gosh, I'm so sorry, I made the mistake again. And I kind of make it about me. Or is it best if I ignore it? I don't have a perfect answer to that. And so if you are dealing with someone in the workplace, it's a different bar, of course, because we're dealing with law. I would say be brief, I apologize, correct your pronoun usage, move on. Don't go into a 10-minute explanation about why you're not a bad person. You're trying to do the right thing. It's not about you. You make the correction and you move on. So I think that might be all the time I have, because with this topic, I would imagine I'm going to have some questions. I want a little bit of time for that. You will be taking okay. Let's use the raise hand feature. Generally, while we're waiting for the questions to roll in, the most important thing here is to remember that if you bothered to attend the seminar and you supervise other individuals, make sure you communicate this to your staff, that the anti-discrimination statute in New Jersey is extremely broad, that we are very protective here, and that the best way to protect your workplace is by properly protecting the protected classes on the list. In hindsight, as soon as I've displayed the NJLAD definitions of all the protected classes, I thought of a few more that are actually on there. So there are a few more that have nothing to do with this topic, but that was not an all-inclusive list. All right, so far we don't have any questions. So if I wonder if you felt I couldn't ramble on for 13 more minutes, I could if you wanted me to. I see some smiles out there. I talk fast, so I think I can squeeze like an hour and a half or an hour and 40 into an hour, which is useful when you have a lot of important information to share.
I'll start with a question. It's Vicki from the Chamber. I know I see some of my colleagues from other organizations here on the webinar. And, so, a lot of times organizations like the Chamber and other nonprofits are hosting events or other things, so they're not, it's not just an employee setting, but, it's a larger group setting. Do the same protective laws apply beyond just the workplace for the hosting organization?
They do. So what I'm kind of picturing when you're saying that would be like girls' night. Is that like something like that? Where
like that? Oh, yes, or just like an event that, let's say the Chamber's holding an event, and we have a lot of business people at that event, so obviously it's a mixed company event. It's not just employees of our organization. So
okay, so let me take your example one step further and tell me if I'm getting it. If you host an event and you have, let's say, bad guy in the audience of your event who perpetrates discriminatory acts against an employee of yours, is the employer responsible for the conduct of this third party person?
Yes.
Fair?
Mhm.
Is that the question? Okay.
Yes.
So the it's a little bit of a nuanced answer. If the chamber is the hosting event and the chamber is the employer of this individual, then yes, definitely. If the chamber is the hosting event and it's two independent members of the chamber, neither of which are employed by the chamber, there's not employer liability. There can be other issues there. I'm trying to think of where it would fall under the New Jersey law against discrimination. And off the top of my head, I can't think of where member versus member. You'd have to take a look at your bylaws and see if there's any like rescission of membership for commission of discriminatory acts. And if there's not, maybe you would want to include it. So the question, it depends on how you look at it. Do you hope to have a environment at your events that is inclusive and use the word safe, although I know some people hate that word, but a comfortable space for everyone? Or is it a free-for-all and anybody can come and behave any which way they want? So that's something that if it's not addressed in the bylaws or not addressed in the rules of membership, it probably should be. But it involves a little bit of soul searching as to which one you want to be.
Thank you.
Does that answer your question?
It does. Thank you.
Okay, super. I'll give you one more thing that I didn't touch on because that made me think of it. If you have a vendor, maybe like the UPS guy, I hate to pick on them because all our UPS people are wonderful that deliver here to my house frequently. If you have a UPS person that's committing discriminatory acts at your workplace, so maybe making comments and your employee comes to you and advises you or you hear it, are you responsible as an employer? Yes, you do have to do something about it. So the person who comes and changes that water jug, the UPS person, at my office, we have a front desk person down in the first floor. He's super, but if he were to do something that was inappropriate and someone reported it, my office would have some responsibility to, I say some because obviously it's a little bit nuanced, but the protection of your employees is paramount under the law. And so if you do receive a complaint from an employee, you should investigate it, even if you think you know everything about it already. Investigation is the best way to handle a situation. I won't say it's expected under the law, although it really is. It's just not. It's not really defined. So a lot of people think, well, somebody came to me, I talked to the other person, I performed an investigation. If we're preparing for litigation, I want the investigation. I want to know what you did. I want to know who you interviewed. I want to know what steps you took and how you tried to fix the problem or how you identified that there was no problem. And so while it feels sometimes like a waste of time, it is the best use of time. The memories are fresh, and that is the best time to be looking into things. Doesn't look like we have any other questions, but does anybody else have any other questions? Okay, super. Well, I would love feedback on this. Admittedly, when you give a seminar about a protected group and you're not a direct member of the protected group, maybe because I overthink things, you wonder, like, am I the right person for this? And can I do right by both the law and by the group that I'm discussing protection? I hope I have done so. And if I haven't, I'm always open for feedback of how I can do better. And I hope I've answered all the employer-sided questions without getting too far afield into the weeds of the discussion. Thank you so much for your time.
Yes, thank you, Amy. It was a very thorough, very good presentation. I'll share with everyone, Amy was extremely helpful to us at the chamber in updating our employee manual. It doesn't seem that long ago, but I think, Amy, it was about 2 years ago that we finalized it, right? So,
I think so. Yep.
and things
And
happen and change quickly in this world. So, really appreciate
especially recently. Yeah.
yeah. And we appreciate your expertise. And I'll just note to everyone that our second in the HR series will be coming up on February 10th. So I know a number of people have already signed up for that webinar as well. So Brigitte, I'm going to turn it back over to you for any closing remarks.
We will be sending out a an email just thanking you for attending today, and we will also share dates for our upcoming events there as well. And thank you, Amy, for your presentation today. I guess if there's no other questions or anything else, I think we have completed the seminar. Nothing?
Great day, everyone.
All right. Have a great day, everybody.
Great day.